Hello and welcome to SQE1 window, and today we will look into private limited companies in our chapter 3 of business law in practice. So we need to look at what private companies are, what are their formalities of filing, and what we need to know for the SQE1. So we have already talked about most common types in the UK. The benefit that we get out of company is limited liability, and there is administration requirement that someone is managing those companies. So by the end of today's discussion, we'll try to cover how to incorporate companies, manage, maintain a company without terrifying our accountants, or you will not be terrified in future once you are working in companies or corporate law. Of course, focus is on SQE, but we will talk about things broadly. So setting up a company, private limited companies are the most common business structures in the UK, and you will watch YouTubers advising never buy property in your own name, buy it in company's name to save taxes. They, of course, why they advise so? So that's fine because they provide limited liability to us. So meaning if the business fails or the property business fails, your personal asset or family home is safe. The company has a separate legal personality capable of owning property and entering into contracts. Incorporation is done at company house. So think of it as registering a very well-behaved friend. It's imaginary friend, but at that point, that imaginary friend need to pay taxes. Another thing, there are promoters, individuals who register company, who set up everything for the company. They are personally liable for contracts signed on behalf of the company pre-registration. Keep this in mind. It is examined sometime in SQE. To avoid personal loss, make sure the company formally adopts and takes over all those contracts which were done pre-incorporation. Promoters are essentially the unpaid stage crew before the show opens. Crucial, but easily forgotten in SQE by folks like. So in an incorporation, to incorporate, initial subscribers sign the Memorandum of Association. And Form INO1 is submitted to Company House, listing company name, registered office, directors, shareholders, and articles of association. We'll talk about them in detail. Once approved, the company's legal person, think of it as the company's birth certificate. Only instead of crying baby, you get the right to sue and be sued. So one thing you should keep in mind, the name must end in Ltd. So the company's name must end with Ltd or Limited, not be offensive and not clash with existing company names. Registered office must be in the United Kingdom. Shareholding structure should be clear from the start to prevent disputes. Always remember, nothing ruins a cup of tea faster than a disagreement over shares. A crucial part, money matters. So, constitution, and I will talk about it, and that's the most important thing a corporate lawyer must understand. Constitution is equal to Articles of Association plus certain resolution agreements which are signed inside company. So that's what Constitution of company is. It's in simple term, it's a rule book of company. With the memorandum confirms initial subscribers, objects are unlimited by default, meaning your business can legally do almost everything. Yes, even a fusion, sushi, and pastry cafe. Unlimited potential, limited liability, a delightful paradox. So, articles and articles of association and model articles. It is often used. We need to understand what is it. So articles create a statutory contract between members and the company. Model articles are often used, setting directors' powers like what they can do, meetings, how they will decide, and shareholder rights. I call it, and we call it corporate governance, how company will be governed. Private companies often strict share transfer to maintain control that it remains within. family companies sometime. In that case, directors act collectively, usually by majority votes. Don't assume solo powers unless your article says so. This isn't a one-person tea party. So articles can be amended by special resolution. Keep in mind, special resolution can amend articles of association, and that's a 75% majority. Some provisions can be entrenched. What is entrenched? Needing unanimous consent to change mean substantial changes. This protects minority interests while allowing flexibility. Think of it as agreeing where to go for lunch. Majority rules, but one stubborn colleague can still veto the choice. I'm not going there. So, post incorporation formalities. After incorporation, you need to keep in mind practical task remains. There are a load of things you need to do: open bank account, appoint advisors, register for taxes, and display the company name on documents. Miss these steps and you risk fines or being struck off. HMRC is a bit like a strict parent. It remembers everything you do. Then you need to do annual confirmation statement. Every company must file a confirmation statement. Annually, we like Form CSO1. This confirms details such as shareholding, who is holding share, and people with significant control, PSC we call it. Late filing is a criminal offense. It is the legal equivalent of forgetting your wedding anniversary and you put yourself in trouble. Say, what is company secretary? Not like in movies, a beautiful blonde, that's different. So private companies can appoint a secretary, public companies must appoint one. The secretary maintains register, ensures statutory filing, and helps with meetings. Small companies, one person can act as both director and secretary, efficient but slightly confusing when writing letters to oneself. So, the next is execution of documents. Company executes documents via seal, like they got their own stamp to authorize signatories, or a director plus witness if there is one member company. Third parties can rely on properly executed document without checking internal authority. Convenient, like ordering a pint at the pub and trusting the barman knows what he is doing. So, where is company record? That maintains statutory register for members, directors, persons with substantial control, PSC, secretaries, resolution, and account. All of it stored. Whatsoever is going on in company. These can be electronic but must be reproducible on paper. Poor record keeping is an offense, and accountants are terrifying when angry. Proper registers save headaches and make the company look competent. So, corporate governance for large private companies. Anthropic is a company with billions of dollars, large private, still it is private, it's not a public company. You can't buy its shares, although I want to buy it. Large companies must include corporate governance statement. Waste principle provides a flexible framework. So leadership, board effectiveness, stakeholders engagement, and reporting. That's very important. Essentially, it ensures transparency without turning your business into parliamentary committee through boardroom debates can sometimes feel that way. Yeah. So the next thing we need to look at, our favorite, is SQE1 tips and pitfall. So some SQE tips: promoters are personally liable pre-incorporation. My favorite. No incorporation steps and registered office requirement. It must be in UK registered office. Understand directors' bars and document execution rules. Don't neglect registers. Marks are lost on small kind of detail if you miss it. In scenarios, ask who is liable, what happens if rules are broken, and how compliance protects stakeholders. Read the question carefully. It's usually the exam's hidden trap. For example, ask yourself, to have a company secretary, how it work in private or public. where it is a must to have a company secretary. Okay, and here I leave you with a question. Cheers and ta-da.